I've got North Dakota Attorney General Wayne Stenehjem on the line talking about today's state Supreme Court ruling on the Fighting Sioux issue. Attorney General Stenehjem, what was your response to the ruling today?
Well, I was happy that 3 of the 5 justices agreed with our position that this is a question that should be decided and that it should be decided now. However, 2 of the justices, without answering the question of whether the statute was constitutional or not, felt that now is not the proper time. And so the net result is that's not enough for in order to meet the constitutional requirement that 4 justices of the 5 determine the law is unconstitutional. They said that the proper time, those 2 said that they felt the proper time would be after the election in June. And so what we have now is a clear indication that this measure will be on the ballot for the June 12th election. But the question of whether the law is constitutional or not will remain and won't be answered, if at all, until after the election, and then only if the voters determine to continue the use of the nickname and logo.
So just to sum up, essentially you did get a majority of the justices. However, the Constitution required a supermajority.
The court did not issue an opinion on whether the law is constitutional or not. They said that since only 3 said they felt that the question should be answered now, that wasn't enough to answer the question, and so they, in that effect, decided they weren't going to answer that question right now and could not answer it because there weren't 4 justices who were prepared to hear it now.
So essentially, if voters do vote to pass the law on the June ballot, we could see another legal challenge, at which point the courts would settle the constitutional question.
That's right. And of course, the question of whether it's constitutional or not having been answered will continue to be a part of the discussion, I would imagine, during the course of the debate, and it will no doubt be brought before the court, but only if the nickname is continued. If the voters decide, no, we're not going to continue the use of the nickname, then of course it won't go back before the court because the issue will be moot. Attorney
General, thank you very much for your time.
My pleasure, Rob. And enjoyed your coverage of the convention. That was quite an interesting weekend.
Yeah, it certainly was. Thank you very much, sir.
All right, bye-bye.
I'm here with Stephen Behm. He's one of the attorneys representing the Fighting Sioux nickname supporters. Stephen, what did you make of today's state Supreme Court ruling on the referendum vote, or I guess the State Board of Higher Education's challenge to the referendum vote?
Well, I think it's a good decision for the North Dakota voters and for the Spirit Lake Sioux tribe, whom I represent, and I believe that it's the right decision. The Supreme Court declined to get in the fray between the Board of Higher Education and the legislature and left it to the voters, seeing that there was no harm in doing that. If the voters basically decide in the way that the State Board of Higher Education fears, which is to support the legislature's the law, then the Supreme Court indicated that it may take a look at the constitutionality of that law. But until then, the Supreme Court essentially said there's no harm, no foul, and we're not going to touch it.
So essentially what they did is they postponed the question of whether or not the law is constitutional and said that, we're not going to rule on that today. We're going to let the vote go forward. And then if somebody wants to challenge whether or not the law is constitutional after the people vote, they're free to do so. Would that be accurate?
That's my reading of it. And 3 of the justices had indicated that they would rule on the constitutionality today, Justices Mering, Sandstrom, and Vandewaal, but they needed 4. And Justice Kapsner and Justice Carruthers indicated that the issue was not properly even before the court. It had not proceeded through the district court level. There was no harm. The Justice Kapsner, in any event, basically saw a Supreme Court ruling in favor of the State Board of Higher Education as an infringement on the voters' right to vote, which I certainly would agree with. And bottom line is, the authority, discretionary or mandatory authority of the Supreme Court is something that should be exercised very sparingly, and that's what two of the justices determined today by agreeing that it was not properly before the court and deferring consideration of the constitutionality issue until June, pending the vote.
Did you get any sort of an idea of how these justices would vote on the constitutional question were that brought before them, or did they finally decide to rule on it?
I'm sorry, I didn't understand your question, Rob.
Was there any feeling from the decision published today how the Supreme Court would rule on the constitutional question when and if it got before them?
Not from my reading. I guess my reading of it is that they basically didn't want to tip their hand one way or the other, and this was the only issue that they were deciding, is whether or not the constitutionality was properly before them in the first place. So they said it wasn't, and if and when it does get properly before them, they were pretty guarded about how they would rule, which is, I mean, that's just how that's how justices are supposed to be, and that's what I expected.
All right, Steve.